Hi, everyone. Thank you all for coming to this special session in celebration of our new issue of the European Journal of English Studies on the place of race in law and literature. So it was guest edited by Andrew Bricker, Cedric Essie, and myself. And we're really fortunate to be joined by some of our wonderful contributors. It's full of wonderful contributors. But we have three of them here. We have Faith Barter, Jess Goldberg, and Nicole Mansfield Wright. And we're really grateful for their time. So, as I was saying, to respect the lunchtime aspect of this, we'll be keeping it to an hour. I will be brief in my introductions and then a little stern in my timekeeping. So, apologies to the speakers ahead of time. But so I'm just going to give an introduction to the concept behind the issue, what Andrew, Cedric, and I were thinking going into it. And then I'll introduce our first speaker, and then each speaker will take about 10 minutes, and we'll keep questions to the end. Okay? Okay. Um, Very briefly, our concept for the issue was not to sort of triangulate race into the field of law and literature. It was specifically to consider why, historically, the field has resisted race as a fundamental category of analysis, and then what the effects of that resistance have been, and then how recent work centering race as kind of the linchpin of analysis in law and literature has shifted the field and revealed its inner workings, which I think all three of these do really well. So we have a really great combination of speakers today for that. And one of our answers, a lot of this is in our introduction if you would like to read it, but one of our answers to the first question, why the field has resisted the category, is twofold. Well, first of all, it is law and literature is part of academia, and academia is situated within the world. And so some of this resistance is just germane to scholarship, and certainly the resistance is not unique to law and literature. But also, we talked about how the field's precarious perch between disciplines has perhaps given it its own sense of minor vulnerability, um, even within academia. And then, though, of course, law and literature are creatures of history, part of the great attraction, I think, for many of us and many scholars historically, is that it has always encouraged the imagination to work against history, um, and to form an idea of the world that's both above time, and then maybe otherwise than it is. And this is what brings many of us to these kinds of interdisciplines, this ability to sort of work against history. Um, so this is, as I say, one of the great joys in the methodologies of the field, but it can also invite scholarship to behave as though it operates above the less savory realities of power structures. And so this is one of the things that we were thinking about when we were putting together this issue, and how we might stage explicitly a conversation about how this imagination has always obviously been formed by these power structures, and how that recognition can help us see a path forward for future work, and then also help us reinterpret the field's own past. So in within the issue, we do have kind of a mix of these two things. We have a lot of sort of forward-looking work that really sets up how we might do future work and sort of gives examples of what that might look like, what a different kind of relationship to race in the field might look like. But then a lot who also kind of look back and do a postmortem on what has happened, and sort of look at how that has set up the field as it exists now. Okay, so today we have three speakers, each of whom wrote a really wonderful essay for this issue to help us do these things. First up, we have Professor Barter. Faith Barter is an associate professor at the University of Oregon, where she is also affiliated faculty in Black Studies and Legal Studies. Her first book, Black Prose, Authorship and the Limits of Law in 19th Century African American Literature with UNC in 2025, explores the creative ways that antebellum Black writers used legal forms as technologies of speculative world making. A former lawyer, Her broader research agenda includes intersections of law with contemporary Black feminist visual culture and experimental fiction and poetry. Her work has appeared in MELUS, in African American Review, Meridians, Law, Culture, and Humanities, and in the European Journal of English Studies, as well as several edited collections. Welcome.
Thank you. It's so nice to see everyone. I see some people here that I haven't seen in a minute. And so, hello. It's good to see you again. It's good to meet you. And thank you, Simon. Thank you, Elise. Thank you, co-contributors. I'm really pleased to be part of this issue. I'm just looking at the time for myself. I'm going to be pretty informal and loose and just sort of talk through my piece a little bit. And I'm happy to talk more about any aspect of it afterwards. My piece is sort of an editorial piece. It's entitled Ambivalence and Empathy. And in it, I'm sort of thinking through some of these bigger, broader questions that Elise alluded to about kind of um, how did we get here in law and literature? And I'm specifically thinking about some of the problems of empathy as a central logic that historically has been a big part of how race has entered into conversations about the field. And as a white scholar of Black studies, this is something that I often experience like pretty acutely as a sort of rupture in between and among the different audiences and communities that I'm speaking to. Because it sort of seems like there should be a natural fit between things like critical race theory, critical legal studies as a kind of predecessor to that, and law and literature. And yet there's still been a kind of slow movement in the field. And I think that we've missed some opportunities as a result. And so first, I want to speak a little bit about just the terms law and literature as really freighted terms. And in particular, I'm thinking with Black studies and Indigenous studies scholars who have called attention to the limits of even applying the word law to other kind of knowledge traditions. That, and by other, I mean other than like white Western knowledge traditions. And so, for example, Angie Porter's work on Africana protocols thinks deeply and carefully about how the category of law is generally understood to be Western or European. And to reference, I'm quoting her here, distinctly European and European derived systems and procedures related to written codes, courts, judges, etc. And she points out that law outside of the European context is routinely qualified to reference non-European cultures. So, for example, African law for European derived systems of law that exist in Africa because of colonialism. And so she prefers to use the term protocols to signal the ways that kind of African ways of understanding governance and forms of relation have operated according to their own logics, independent of a sort of white Western imperial tradition. And Indigenous studies scholars have made similar observations about some of the problems of using even a term like Indigenous law. So here I am thinking with Ablofsky, Deer, and Richland, who in a collection that I believe Simon maybe edited, talk about these sort of gaps that Native people have often been historically regarded as lawless prior to contact with white imperial and Eurocentric legal models. And the Native traditions vary widely by tribe and place, and also observe different standards of knowledge, of proof, and authority. And so, as they write, quote, Indigenous law draws from multiple sources, is adjudicated in diverse fora, and has continued to grow and develop, including through the encounter with Western models of adversarial legalism. And so, I point this out first to think of how the kind of outermost limits and some of the most basic ways that we talk about the field, we're already importing and normalizing and naturalizing white Eurocentric models of relation in the project. And literature has the same problem because historically in academia, discipline of literature or English is again invested in reproducing legacies of white Eurocentric culture. And we see that becomes very visible when we start talking about genres of literature. Um, and if we have a genre like the slave narrative, for instance, or the freedom narrative, one of the few race-conscious genres in the kind of Western literary canon, we also note the ways that particularly Black authored texts tend not to easily fit within existing literary genres that were simply not built to contain those ways of knowing. So it really matters, I want to say, that we trace and name the intellectual and experiential limits of white Eurocentric knowledge traditions if we're serious about putting race at the center of a field like law and literature. And here I want to cite Carla Holloway, who has asked the question, what makes a body visible enough for literary act and legal notice? And I want us to try to think of law and literature as a field that actually contains lots of possibilities for innovation. First, just by expanding and enlarging what we may think of and call literature and law. And so the fact that both law and literature are fields that are discourses invested in narrative, in traditions of world making and world building, I think this actually kind of starts to point to the ways that the field has some sites of possibility for liberation. And this might be counterintuitive because often when we're thinking about race, law, and literature, we're obviously wanting to grapple with and contend with the very violent histories that are encoded in the ways that law has been mobilized as an instrument of racial oppression. And that kind of gets me to the way that empathy has historically entered some of this discussion. And it exposes some of those fault lines. So there's a lot of work on empathy that often surfaces around empathy for jurors, judges, lawyers, etc. And historically, I'm not discounting the kind of social goods of empathy or whatever, but I think it's a limited model. And I get really uncomfortable when it gets invoked as a bridge between law and literature, where it's usually functioning as a way of suggesting that literature can cultivate empathy in people who have power to make laws. And again, great, love that. But embedded in that assumption is a kind of automatic defaulting and centering of whiteness, of law, and it also calls upon marginalized artists to be teachers and to help correct the sort of white lawmakers. So there are these hierarchies that are kind of embedded in these assumptions. Catherine Temple, who I think is here in the Zoom, has noted this in relation to Kill a Mockingbird, one of the kind of classic examples where that text is cited as a sort of via bridge to empathy. And Temple has written that the novel suggests that empathy can be owned only by white people. And I think that's really kind of a lot of the underlying problematic here. Jade Davis has made similar arguments. Namwali Serpell has made similar arguments about the sort of limits of empathy as something that ends up restaging trauma, oppression, and so forth. And in addition to like that problem of empathy, I would just add that I think it also assumes that individuals will apply their empathetic energy in the ways that we want them to, which, as someone who regularly teaches texts like various Black autobiography and freedom narratives, and having the experience of seeing white students extend empathy to enslavers as opposed to the enslaved authors of the text, I think also kind of signals one of the sort of limits of empathy. So I'll just leave by saying that for me, as someone who's interested in how law and literature can be a site of liberation, I want to kind of push us towards some of the questions that, for example, Jennifer Nash has posed in Black Feminism Reimagined about how can we understand law not only as what she describes as the paradigmatic site of anti-Blackness, but in Nash's words, tracing how it can be a location of radical freedom dreaming and visionary world making. And so rather than directing our affective energies in the field to around questions of empathy, instead, I wonder, can we direct those affective energies toward creating entirely different worlds and landscapes? So I think that's about it for my time. So I'll stop there, but I'm happy to talk more, and I'm really looking forward to hearing from the other panelists.
Thank you so much. I have lots of questions about that. I'm working on empathy and compassion myself, so I will have lots of questions for you. But moving on, the our next speaker is Jess Goldberg, who is a community organizer currently working as an assistant professor of English and director of the Gender and Women's Studies program. That's a lot of work at New Mexico Highlands University. They are the author of Abolition Time: Grammars of Law, Poetics of Justice, which grounds disciplinary methods of close reading within conceptual frameworks of Black studies, queer, trans, and feminist studies, carceral studies, and abolitionist praxis. With Marquise Bay, she co-edited Queer Fire, Liberation and Abolition, a special issue of the journal GLQ, and her academic writing is published widely in journals and edited volumes, including ASAP Journal and Teaching Literature and Writing in Prison. Welcome.
Thank you so much. And it's lovely to see so many of y'all on this call. Happy to join you from the Mountain Time Zone this morning on the unceded historical territories of the 19 Pueblos, the Apache, the Comanche, the Dene, the Kiowa, and the Ute here in northern, what is today called New Mexico. I'm going to start my timer. So what I want to do is I have handwritten notes I'm going to talk from, but I'm going to start by reading the first few sentences of my piece from the issue. It's titled Being Beyond Law, Race and Grammars of Dispossession in Black and Indigenous Literatures. And it opens like this. In its function as a world-ordering force holding together social contracts inaugurated by cis-heteropatriarchy, ableism, and the racial ethnic taxonomies of colonization through the violence of enforcement, law does not merely result in racist effects that belie its morally neutral nature. In the afterlife of slavery and in the ongoing unfolding of colonialism's iterations in the nation-states of the imperial core, law is racist. As a scholar who regularly teaches courses on African American and Indigenous literatures with a focus on the legal construction of race, I insist on moving past the banal observation that literary texts demonstrate the persistence of racism within the legal structures of the United States. So that's that's my presentation. That's all I want to say now. So that's basically my thing in thinking about law, literature, and race is a kind of like getting a kind of like wanting to reassert the poetics and the importance of like the how of literature. How does literature do its work at the level of poetics, at the level of aesthetics, at the level of style? In the way that I want to assert with, and I'm going to read two quotes really quickly from Toni Morrison and Christina Sharp. I want to assert over and over and over again that literature is not sociology. Literature is not social data. With building on what Faith just said about empathy, right? Like literature is not this thing that you just read to become a better person. The Nazis read books too, right? Like this idea that literature is this like source of data that we go to and we learn things, especially the way that the assumed white reader who learns about cultures that isn't theirs, right? All of the way these are problems we all know about, right? But they still like find out their ways into classrooms in the 21st century. And it like I'm going to use a really non-academic term. It annoys me. It annoys me the way that Black and Indigenous literatures, especially, but then we can extend this. I see it happen with literature by disabled authors, literature by trans authors, where literature just becomes this like well of social data that we like now we the straight cis white reader, I'm only one of those things, like now knows about an experience of injustice that we didn't know about before, and we've had the right feelings, and like in doing all of that you haven't actually engaged with the literature as literature, right? Literary language as literary language. And so I have two quick quotes that I want to look at. One from Toni Morrison's essay, Unspeakable Things Unspoken, which I teach every year somehow in some class because it's just the essay. And at the end of the essay, she has this beautiful sentence where she says, quote, "To those who talk about how as well as what, who identify the workings as well as the work, for whom the study of Afro-American literature is neither a crash course in neighborliness and tolerance, nor an infant to be carried, instructed, or chastised, or even whipped like a child, but the serious study of art forms that have much work to do, and which are already legitimized by their own cultural sources and predecessors, in or out of the canon, I owe much." End quote. And then Christina Sharp puts a fine point on it in her most recent book, Ordinary Notes, where she writes, quote, "There is a certain mode of reading connected to a tradition of colonial practices in which every book by any Black writer appears as sociology. Then all of that book's explorations, its meanings, and its ambitions lodge in a place called identity." So why am I talking about this in a law and lit forum? Because I find that, and this is maybe influenced by how much teaching I do. Since finishing grad school, I've had four teaching loads. I've not been primarily a researcher. I've been primarily a teacher, and the amount of times that like with students reading the kinds of texts that I teach, and I'll talk about four of them very super briefly, do not do them justice, pun intended. Um, I will often in our class discussions of like, well, what's the point of reading something like Song of Solomon in relation to law? And we like discover the lesson that like, yeah, the law doesn't protect Black people, it's racist. And it's like, you knew that before you read the novel. You don't have to read a Toni Morrison novel to know that the law is racist. You don't have to read an Layli Long Soldier's book Whereas to know that that 2009 apology that the United States passed to indigenous people is bullshit, right? Like you don't have to read like you don't need the literature to tell you the content that like law is racist. Like that's like we have data to do that. Literature can't just merely be your data to prove law's racism or like give you the like demonstration of the law's racism, right? Like if you need to read a novel to learn that, like that's a whole other conversation you need to have over in the corner somewhere. So like for me, what I'm doing in this essay, that I wrote is I'm drawing on a whole bunch of theorists in Black and Indigenous studies. And while I could say, look at the works cited page, I'm going to voice their names just to be like, it's important to kind of say who we're in conversation with. Cheryl Harris, who I think I assign, and I tell my students, you're allowed to groan at how long it is, but this is the iconic critical race theory text that you must read in this class. I'm teaching a long lit prose seminar this semester, and I let everyone groan when we did Cheryl Harris because it was so long, and I was like, and yet you will read it all, including the notes. I'm of course so thinking about her work on whiteness as property, Saidiya Hartman's Seen This Objection, which is a long literature book. I had someone tell me it's not once, and I'm like, I won't even listen to that. Chapter 3 is all I have to say. Sylvia Wynter as a theorist of the human and the way that so much of legal discourse assumes a certain kind of reasonable man, right? Alexander Wahelier's Habeas Viscus, which I'm again kind of assuming folks are familiar with, but great text on Black studies and law. And then in Indigenous studies, folks like Jody Bird's Transitive Empire, which I teach often in literary theory, Eileen Morton Robinson, who builds on the work of Cheryl Harris and thinking about the white possessive, Luana Ross, who's a great Indigenous sociologist who writes about incarceration, and Brenna Bandar, who writes about what she, in her book, The Colonial Lives of Property, something that I find really useful for what I articulate as property as a legal grammar. And so basically what I'm doing in this article that I wrote for this special issue is I'm trying to think about how Black and Indigenous literary texts, African American and Native American literary texts, through their poetics, are doing something other than something in addition to um, proving racism or giving like the experience of racism, and are instead like articulating the way in which race itself is what I call in my book Abolition Time a grammar of law, right? That like law actually, and this is my abolitionist bent. I don't think law can be cleansed of its racism. Like law's grammar, its structure is racist in the West. Period. right? Like, I'm not ready to have a conversation about like what a non-racist or an anti-racist law would be until we completely overthrow racial capitalism and colonialism and imperialism, and there are no more imperial core states, right? Like, that's where I'm at. So I look at and I'm at yeah, so my I'll close by just quickly talking about the four texts that the literary texts that I include at the end of this, and all four of these are actually this essay that I wrote for this special issue wound up becoming basically the shell syllabus for the law and lit class I'm teaching this semester. So thank you for letting me write my syllabus in an article form. But the four texts are Toni Morrison's Song of Solomon, Louise Erdrich's The Roundhouse, Emler Bese Phillips' Zong, and Layli Long Soldier's Whereas. And I'm just going to quickly name that one of the things that Song of Solomon does, besides tell us the obviousness of like white people get away with killing black people, and they have for 400 years, um, is that in giving us Milkman's father as a character who is so deeply flawed in the ways that he is through different various forms of characterization, the novel not only critiques racism, but actually undoes logics of property. Erdrich's The Roundhouse, in giving us a first person point of view protagonist who's a teenage boy in a story that's essentially about gender violence against an adult woman, allows us to really deconstruct patriarchy in a much more robust way than to simply say that like the law fails to protect indigenous people. Um, and then, of course, Phillips Zong and Lady Long Soldier's Whereas not only cite through intertextuality legal texts, but through poetic spatialization, inhabit those legal texts in order to undermine them in different directions. And my final point that I'm just always going to keep making for the rest of my career, hopefully I don't have to, is attending to the ways that those texts do their work with language is much more important to us than mining them for social data. It is disrespectful to the literary works to view literary works by Black and Indigenous writers as social data about the experience of racism. So I'll end there.
Thank you so much. Okay, we are miraculously keeping on time. Thank you, everybody, for being so disciplined about this. And then we have our last speaker, Nicole Mansfield Wright, who is an associate professor of English at the University of Colorado Boulder. A Yale PhD, she's the author of Defending Privilege, Rights, Status, and Legal Peril in the British Novel, published by Johns Hopkins University Press in 2020. Her articles and book chapters have appeared in a variety of journals and edited collections. Recent publications include an examination of conservative religious publishers' editions of classic novels. Oh, I want to read this. And advocacy for current right-wing legal objectives in the 2025 Cambridge Collection, British Law and Literature in the Long 18th Century, edited by Melissa Gans. Her presentation today is excerpted from her recently published article, Savage Masters, Dehumanization as a Strategy to Challenge White Legal Authority Before the 1833 Slavery Abolition Act. Welcome.
Thanks, Elise. And I think that my presentation is in conversation with the work of Faith and Jess, because one of the ways that my article originated was from my book, and one of the questions there was, how was literature complicit in convincing general readership that the privileged were the most pitiable victims in society? So what kind of flows of empathy are being controlled there? And another question I was asking more specifically was how does literature convince people to relinquish some of their most cherished beliefs about whom the law ought to protect? And in particular, one of my chapters looked at pro-slavery writings, and I was really puzzled to the extent that those have been relatively neglected. And I think that's because, in part, scholars have a fear of centering white people in discussions of race when that's gone on for so long. And so there's a bit of those works are kind of radioactive, or have been historically in literary studies. So the premise of my article for European Journal of English Studies, is that there was a small group of British and early American authors and poets in the 1780s through the 1820s who claimed that cruel treatment and in some cases just owning slaves disqualified white people from their accustomed role as stewards of the law and even reduced them to savages. And that was a real audacious reframing because the customary racial hierarchy holds that white lawgivers are rightfully superior to Black targets of law. And so I wanted to talk a little bit today about some other origin points of my article before looking into a couple of examples. So one of the combinations of sources that I was thinking about was a few passages from Thomas Jefferson's Notes on the State of Virginia, where he tantalizingly hints that slavery impedes and impairs white children's development and their ability to be part of a lawful society. And the passages aren't long, but they're really striking. And it seemed to me, this was back a few years ago, I was thinking about that text in concert with a couple of really recent interventions. So Metzel's Dying of Whiteness and McGee's The Sum of Us. And both of those books claim that racism harms those who are racist. The damage is multifaceted. And so my article really explores how did that idea originate, or how did it evolve through pro-slavery and anti-slavery texts in the late 18th and early 19th centuries. And so I especially zoomed in on the term savage. And here I kind of was thinking back to Raymond Williams's keywords from the 70s. So he, in his preface to Keywords, Williams focuses on words which, beginning in particularly specialized contexts, have become quite common in descriptions of widespread thought and experience. And I'm looking at how savage becomes legally activated in some of these texts and what work it does across law and literature to question, uphold, and challenge racial formations. Okay, and then a third source I was also bringing on board was some German and French work on degeneration. So this may be familiar to some of you, but in the 17th century, 18th century, we had several thinkers, including Buffon, in his multi-volume work on natural history, including the history of humankind. He was originating this idea that we now see in replacement theory of the decline of the West. So he had a theory of degeneration by which species, including plants, animals, and human beings, begin in their idealized form, which according to him was a white European, and they degenerate over time. And what I trace in my article is how anti-slavery advocates turned that idea on its head. They were claiming that the act of slaveholding and of brutally punishing one's enslaved captives, that's what made someone degenerate and made someone descend in the great chain of being. And you can see an illustration from from an English translation of Buffon's Natural History in 1791. And this is published right around the time that many of the first poets and authors that I trace are working. So to get into an example, here's an excerpt from Anne Yearsley's poem on the inhumanity of the slave trade from 1788. And it's just such a vehement, angry poem. And it ends with this apocalyptic vision of slaveholders being wiped from the earth because they've become too savage and because they've angered God. And so here's one passage. Whence comes thy right to barter for thy fellows? Where are thy statutes? Whose the iron pen that gave thee precedent? Give me the seal of virtue or religion for thy trade, and I will ne'er upbraid thee. But if force superior, hard brutality alone become thy boast, hints to some savage haunt, nor claim protection from my social laws. So you can see the vocabulary, the legal vocabulary here is much more explicit than in the sentimental poetry of anti-slavery that had been dominant in the previous generation in the 18th century. And as I mentioned, at the end of the poem, she just has this vision of God wiping out the slaveholders and bringing Native Americans and also Black people, having them ascend on the in the legal hierarchy. Okay, so 2 years later, after Anne Yearsley published her poem, I found this really intriguing debate during the first Congress in 1790. And I was really puzzled why other scholars hadn't extensively taken this up, because it also engages with this question of racial hierarchy in law. There were some Quaker petitioners who claimed that slavery weakens the mind of slaveholders. And this Southern representative from the Carolinas, William Lufton Smith, comes on the floor and has this tirade defending slaveholders and claiming, strangely, that literature proves the expansion of literature in the South proves that slaveholders are indeed cultured and they're not descending into savagery. But he also has this interesting line: if the slaves are emancipated, there will be no whites at all. And so this is in the context of an extensive discussion where he's claiming that slavery and slaveholding does not unfit white people for stewardship of the law. Okay, so I just wanted to end with some implications of this discussion. So some of you may have heard of the history and tradition movement in legal studies. So this is a right-wing legal movement that has been disproportionately influential. We can see their traces in and their fingerprints on many of the recent Supreme Court decisions, and I expect to see that in some coming down the pipe any day now. Basically, the premise of this history and tradition movement is it goes beyond originalism. So the notion is that we need to look to these 18th century texts, and in some cases 17th century text, as the substrate according to which we evaluate whether laws are acceptable or not. And what I'm suggesting is that these forgotten authors that I'm tracing, so not only Anne Yearsley, but others like Charlotte Tana and other authors and poets I trace in my article, I see them as an alternative archive for today's history and tradition movement. And I think it's not accidental that these aren't household names, because if they had been more disseminated, if they had been shepherded through generations on syllabi, they would threaten the history and tradition canon that these right-wing scholars are trying to bolster today. So these are not just dusty texts in an archive. They really have, I think, a great potential to challenge what we're being told are the text by which we should abide. So thanks so much for listening. And I wanted to thank Andrew Bricker, Cedric, Simon Stern, and Elise for making this issue possible.
All right. Thank you so much, Nicole. This is great because we actually have enough time for significant questions. I will keep the queue. So you can go ahead and raise your hands and I will make sure that I get everybody. So you can do that however you want. You can use the little hand thingy or you can just raise your hand if you are visible. And I will take you down. Anyone want to get us started? Simon.
So while people are thinking of questions, I just wanted to put in a pitch for the LCH syllabus project. So a number of people referred to their syllabi, and there are many people in the audience who have great law and lit syllabuses as well. So we're collecting them and making them available on a password protected basis on the website for graduate students, early career scholars. So I just wanted to put in a pitch for that. Please send them in. We'd love to have them. I just wanted to say that while people are getting started to think of questions.
I can also get us started with a question because I have a lot of them. So I'm just going to take moderator's privilege and do that. I think this is actually for at least both Jess and Faith, but also Nicole, I think you're working sort of more specifically with this. Um, it occurred to me that one of the strands that you all pulled out, which is, the problem of using literature and art form as a source, as a reservoir of historical and sociological data, rather than as an art form, is kind of a problem that law and literature struggles with as well. Not just when it comes to like texts that have to do with race or by Black authors or by Indigenous authors. Um, Law and literature tends to struggle with this as well. The tendency to look to especially historical literature as simply a kind of data bank for historical information and data. And so I was wondering if you felt like this is a particular problem of our field. Is this kind of a problem of interdisciplinary work? Is this problem of working between sort of art and sociology or law or sort of disciplines that favor more statistical and empirical analysis? Just if you guys had any thoughts on that. Yeah,
I have
Nicole.
thoughts.
Jess. Yeah, sorry.
Yeah.
Go ahead, Jess.
I just saw Nicole on mute, but go ahead.
Okay. Yeah, I have thoughts. I think that this becomes a function in some ways. I don't think it's unique to law and literature as a field, is what I want to start with. I think that, and I also want to acknowledge your point that it doesn't just happen with Black and Indigenous author texts, but I think that there's a certain kind of it has a different dimension when it happens to text by minoritized authors. Um, but I think it happens when literary scholars um want to do work that is explicitly aimed at certain social justice aims. So this also happens in like eco-criticism, for example, right? Like we'll read a poem about climate change, and by reading the poem about climate change, we will fight climate change. But like in reading the poem about climate change, we're basically reading like the images, and we're not talking about meter, we're not talking about rhyme, we're not talking about enjambment, we're not talking about the craft of the poem as a piece of language, right? I think that that is a function of the kind of urgency that a lot of us genuinely feel and should feel, right? Because I'm gonna say a quick thing about one of the central things about my book Abolition Time is it's extremely self-conscious of the limits of literary studies methodology. Like Abolition Time is kind of an argument that like if we want to again abolitionism is a particular position. It's not like what everyone who studies law does. But like if you're an abolitionist, like you got to put down the book and you got to go out into the streets. You got to go do stuff. Because literary methodology, literary studies, literary criticism can only do so much. And I think that part of the mining literature for social data is an expression of this anxiety, I think, that literary scholars who are conscious of social justice issues have of like, there's the urgency to solve the problem that is such a problem. And so like let me show you in my righteous and like rightful passion how this Toni Morrison novel shows us the terribleness of anti-Blackness, right? Um and close reading and doing the like nitty-gritty stuff that Morrison herself asks us to do takes time. Close reading takes patience and time and slowness. And I think that the urgency of the stakes of what we're writing about can sometimes make it really hard to do the slow stuff. So that's that. I have a lot of other thoughts, but that's the first thing that I thought about to your question.
Jess, I totally chime with your thinking, and especially your note on ending on the importance of the process of slowness. That really ties into something I've been wondering about, which is the kind of proliferation of interdisciplinary legal movements. And I think there's some reaction that that occurs when the law and literature movement emerges in the 1970s after the emergence of the law and econ movement in the 60s. And that was all about promoting economic efficiency, not being slow, producing. And then we have the legal imagination coming out of from White coming out in the 70s. And I think there's a reaction to that. But I think in its eagerness maybe to rebut some of the excesses of the law and econ movement, maybe we ended up taking up some of their practices. But I think there's a relationship there.
Agree with both Jess and Nicole. Certainly, I don't think it's unique to law and literature, this kind of neglect of literature as art. One thing I would want to add is I actually think we also maybe are neglecting the craft of legal language in this kind of binary because there's often this sort of presumption that law is not art, is not narrative, is not written by human beings. And this is where I kind of feel like both of these disciplines have a lot to be able to say to and learn from each other. And so I also want to kind of think about how we can do more to engage with like not just the fictionality of law, but the craft of law, the artistry, the manipulation of language. And I always want to close read legal text at least as much as I want to close read literary text.
Can I add one more thing?
Yeah, please.
I also think there's maybe this is silly and maybe this is an obvious play, but I also think there's this idea of like formalist close reading is regressive. And like if you're doing progressive political work, you don't do formalist close reading. I also think like that's still a bugger that haunts us, right? Like even though I feel like there's so many literary scholars who do it really well, but I think that's also part of it.
I agree, yeah. Mark says close reading hard to do with a shadow docket.
And that's serious, right? Because then like there's also this whole other way that law gets made that's not captured in language, and that's a whole different thing, right? But that also I think gets at why I think that there's a lot of value in, for instance, like what Angie Porter is doing to push us to think about using terms like protocols. And specifically in her work, she's thinking about Africana protocols to find other language to talk about governance when what we mean is like governance and relation, which is not the same thing as text, to Mark's point.
Yeah, that's a really good point. Okay, Lalu.
Yes. Hi. I am so sorry first that I have my screen off. I'm in the library in my university and
No worries.
yeah, I'm so sorry.
No, don't worry.
I had to like scuttle into a room so I could ask the question. I was going to, I guess, build on Elise's really important question. And I think the really insightful answers that the presenters have given. Thank you all for presenting your work. And perhaps take a different tack to the question. So I appreciate and mostly agree with the concern that reading marginalized authors, so Indigenous authors, Black authors, reading the literary texts as principally sources of like sociological inquiry sort of reduces it and doesn't quite engage fully with it as art. But I wonder where we, I guess, situate. So I work background, I'm Nigerian. I work with like Nigerian literary text, and I work in Canada. So I also work with Indigenous literary texts in Canada. And so, especially in the context of Nigeria, I've found that a lot of authors of the early post-colonial period understood themselves to be doing history, to be doing sociology. So when you read someone like a Chinua Achebe or a Florent Wapa or Buche Metesa, they write explicitly, we're writing this to present a written account of who we were prior to colonization, who we are because of colonial contact, and to write back against the colonial misrepresentations of reading that explicit intention that the authors put forward and using that as like motivation to read their text for the way they wrote it cannot be all that bad, right? Like it sort of also leans into the purposes for which these literary texts were written. And within the many indigenous cultures in Nigeria, at least, literature functioned as a way to preserve history. So not just as a form of art, but as a way to repeat the histories of people, especially the communities that were involved in oral traditions. Like literature was how they repeated and preserved and documented their history. So I guess I'm making a case for why it's useful to read literary texts, especially in the indigenous context, especially in context of peoples that have encountered or experienced colonialism, for reading their literatures as also a source and an important source of their sociological history.
Laulu, I think that's such an interesting point, and weaving it into this discussion is really important. And it makes me think of if you're familiar with the novel Americana by Adichie, there's that inset where the character has this blog where she's collecting data as someone who's visiting America from Africa, kind of observations on how race works in America. And it's meant to be satirical, but I think it does also touch on your point that there was this responsibility, as these authors envisioned it, to bring their history to a wider audience, and to dispel misconceptions. And I think that's in tension, but a productive tension with what we're talking about.
Yeah, I would just say thank you for calling our attention back to this point. And I would just add, I think ideally, we want to kind of hold both of these things as possibilities, right? And we want to kind of cultivate reading practices where we are engaging with what the writers themselves understand themselves to be doing and say that they're doing. And so, for example, like the way that I kind of encounter this in my book is that I'm looking at um, Black writers in the US in the first half of the 19th century and really taking seriously the ways that they are engaging deeply with law, which is a different reading from how historically they have been understood or read kind of primarily as witnesses of their own pain. And I'm kind of really wanting to sit with and take seriously the importance of that testimonial function and read for the ways that they are also practicing forms of collective memory and also like speculative imagination. So I think we want to add complexity to our reading practices wherever we can, in ways that honor the kind of multiple functions that writers are engaging in their art and in their writing in general.
Yeah, I really appreciate this point, Laulu, that like the literary works from the perspective of those who write them are often written to be um, a counter to erasure and in some cases wholesale destruction of histories, right? I'm thinking about the Phoenix Library opening in Gaza recently, right after Israel literally destroyed Palestinian history, right, through scholasticide. So yes, 100%. I think to expand a little bit on the point of like doing both and seeing literature as both is making what might, as I'm saying, and I'm annoying myself of like a distinction between reading and literary criticism. Because one of the things that like I think reading a novel or a poem that an author has written for the purpose of kind of offering up a history that has been destroyed or erased and reading it and talking about it in the kind of social reading practices that we have is like very valuable. I think what I'm talking about is in the professional realm of literary criticism, when a scholar and all of their accolades and credentials reads a literary text that the author has already reads you referenced Achebe, reads Things Fall Apart and takes the narrative, repackages it in academic language, and just tells the readers of literary criticism, here's the history that the novel tells. Well, if you're like, then go read the novel, right? Like when literary critics see themselves as digging up, and I'm using these like really overdetermined this really overdetermined imagery intentionally, and I'm very much drawing on Morrison's essay on Unspeakable Things here. She talks about treating literature like ore that you mine and refine. And that's what I'm looking at. The professional literary critic who goes to the poem or the novel, excavates the data, shines it up using their professional tools, and then says, look at my brilliant argument, when all that scholar's brilliant argument is an articulation of what the novel or the poem already says is a history that has been erased. Right? Like if I read one more journal article about how Beloved uncovers the erased history of slavery, my eyes are gonna fall out of my head. Right? Like that's what Beloved does. Right? Like I don't care how much jargon you have in your toolkit to say it, that's what Beloved does. So I think that I think that like reading and like the profession of literary criticism in the West by Western scholars affiliated with wealthy Western institutions, right? This is also about the positionality of scholars, that treating it as ore to be refined and presented is I think that's what I'm going to be continue to be very critical of. However, I have to remember not to treat that as the only thing that's happening, because reading and the social practice of reading is also very important in all of the ways that your question rightly pushes back on us with, and that Nicole and Faith have spoken to.
All right, thank you. Other questions? I think we have time for at least one more. That mean I get to ask another question? Come on, someone else. Yes, Catherine.
Well, this is more a couple of comments, which is why I hadn't raised my hand. But um, when I see people mining novels, as you put it, for history of emotion studies, right? I mean, it is a similar problem in these different and areas. What I think we bring to it is that understanding of form, the close readings that we do, and without that, it's what we used to call in law school issue counting, or maybe in literary studies emotion counting or something like that. That's what I tried to do in the book, was to get past that. And the other thing I was thinking about, the whole idea of literature as teaching us empathy for anyone. I mean, if you've ever been in an English department where everyone's reading literature all the time, you kind of know that's not how it works, right? Yeah. So I just, a lot of what was said tonight really resonated with me, and I enjoyed it a lot. And this was my opportunity to get that in there. So thank you. Not a question, as I said.
I think, Catherine, I agree, and I think that I'm thinking back to Suzanne Keen's empathy in the novel, which kind of really challenges this idea that novels instill empathy. But I also think part of it is, and I'm just kind of gesturing broadly to what's happening in higher ed now. Part of this instrumentalization of literature is a reaction to the defunding, to the pressures that have become even more intense. So we're trying to, I think scholars sometimes try to gesture and say, okay, this is a reason your child should.
It's really important, right? Yeah, I think this goes back to the beginning of Law and Literature, that really old essay that was in PMLA had made this argument that why are we turning to law when we're literary scholars? It's because we're concerned about the humanities going down the tube. And now we're even more concerned, right? And I had to laugh at the idea of wealthy institutions, because so many of our institutions are not wealthy at this moment, right? And we're being asked to justify ourselves every single day.
Yep.
Yeah. Depressing, sorry.
No, it's being in academia right now is a little bit
Yeah.
depressing. So yeah, Jess.
But I
Well,
do
Jesse,
think like using our reading skills, working a bit with farm, working with close reading, and demonstrating what we can do is one way to show our worth to in the academy. This is something
And
that
it
they don't do in sociology.
and it is always convincing to students. That's really, I'm sure we all
Yes.
know from teaching,
Hmm.
students are totally on board.
Hmm. Hmm.
my
All
I
right,
also think
Jess,
one of our contributions is slowing down, as we were
Mm.
talking about slowing down. When I teach To Kill a Mockingbird, we might, read a passage, talk about it, then I have them read it over again, and I have them read it over again, and every single time they get something new out of it. And that's for students who breeze through so many different things every day. That's a real insight that they value.
I think that's really true. So we are actually at time, and I want to respect everybody's time. If people want to linger a little bit, I have about 5 more minutes, and I'm happy to stay and moderate a little bit more discussion. But thank you so much for coming. This is a really wonderful discussion, and I can let you go if this is time for you.